May it please this court, Huni is my name. Addressing this court in the defense of Tatenda Moyo, who stands charged with the crime of robbery in aggravating circumstances as defined in section 126 subsection 1 as read with section 126 subsection 2 of the Criminal Codification and Reform Act. The defense maintains its position that this is a case of mistaken identity and the state failed to prove its case beyond a reasonable doubt. The law is clear that in a case of this nature, the onus lies on the state to prove its case beyond a reasonable doubt. This was discussed in the case of State versus Isolano, which was stated with approval in the case of State versus Chikanga, which stated that the state should prove its case beyond a reasonable doubt, establish all material facts, and where doubt exists, then the court cannot convict. The defense is very much alive to the provisions of Section 269 of the Criminal Procedure and Evidence Act, Chapter 907, which states that conviction can be made based on the evidence of a single competent and credible witness. However, the defense would like to direct the court's attention to what was stated in the case of Ara versus Mukwena, where the court said that in the case of this nature, where evidence is from a single witness, then there should be clarity and satisfactory in all material respects. From the above, the defense admits that in a case of this nature, whereby the state heavily relies on the evidence of a single witness, there was need for corroboration. This was further cemented in the case of Banana versus the state, whereby the court stated that in a case whereby the state relies on the evidence of a single witness, there is need for credibility, reliability, and accuracy. The identification evidence is not scientifically reliable. The witness, Mr. Dwe, testified that he was attacked from behind. He observed the assailant for approximately 30 to 45 seconds, and this was at night with the nearest streetlight being 8 meters away. Additionally, he stated that he was intoxicated and he encountered the assailant for the first time. The defense argues that the opportunity for accurate observation was limited and possibility of mistaken identity cannot be excluded. The identification parade does not remove the doubt of mistaken identity. There is uncertainty regarding the initial identification. A later identification at the police station cannot cure this doubt and these weaknesses. Mr. Dube has suffered a grievous attack, and as anyone would, he is seeking justice. However, in his quest of seeking justice, he based his memory on a memory of a stressful situation, which is a distant memory. He identified the accused on a presumption and not on a stable knowledge. The defense alibi, Mr. Admirachirao, had testified that he was with the accused celebrating his birthday at Mijabiao from 7 p.m. to 12 midnight. The onus lies on the state to question the credibility of the alibi. In the case of State versus Mutandi, the court observed that the police have got a duty to investigate the credibility of the alibi, and it is the duty of the state to disprove the alibi presented by the defense. Bereje, in the state of State versus Chimize, further reiterated that the police have got a duty to investigate and the state has got a duty to disprove the alibi. Adopting the above rulings, the defense highlights that the alibi presented remains unchallenged. Your Worship, suspicion might be present, but it does not replace the burden of proof placed on the state that it should prove its case beyond a reasonable doubt that Tatenda Moyo is guilty. Accordingly, the defense prays that the accused, Tatenda Moyo, should be acquitted. Unless the court requires any further submissions, this marks the closing of the defense submissions.